Now back to the show. This is The Law Show on CL 650.
You know that song was going to come up, didn't you? Hey, welcome back to The Law Show. I'm Zach Spencer here on CL 650. We're talking about the breakdown of relationships. It's very difficult and confusing. We're focusing for the remainder of the show on children and how that is affected when a family breaks up. We have family lawyer David Halkett here from Macquarie Hunter. He's a partner, and Sarah Morris, associate at Macquarie Hunter in Surrey. You're at Central City, Surrey, right above the SFU campus there.
Correct.
And now, Sarah, I just want to compliment you. Last time we had you on was your first time. I thought you did a great job. How are you liking radio? It's fun, huh?
Yeah, I have to say it's a nice break from the office.
Now, you listen back. I know everybody does when they do their first show. They listen back and you critique yourself, but I think you did a great job.
Well, thank you, and thanks for having us here.
And your daughter? It's daughter, right?
Yes.
What does she think? She's the ultimate judge, right?
Yes, she got the earbud in the middle of her soccer game so she could listen to it while it was being played back. So she thought it was pretty cool.
Yeah, it's different. It's
yes.
like, yeah, you know, and she didn't use the old joke. You know, like David, he's got a face for radio, right?
Thanks a lot.
I tease, because everybody uses it on me. All right, so we're talking about children for the remainder of the show, and this is obviously the part that really is heart-wrenching for families and how you divide the time with children. And it's you mentioned you've got a family where everybody's in together every day,
Exactly.
and then that's not the case. So is the biggest part of holding hands with people who are breaking up is the life you had is no longer the life you have now?
Yeah, and usually what happens is they expect things to remain the same.
Mm-hmm.
And then over time they will, settle it at the time when they're finally able to get over the fact that it's not going to be the same.
Mm-hmm.
And it's amazing how every small little thing that the other spouse did that they thought wasn't good parenting over the time, even though they didn't raise it as an issue then, becomes an issue after separation. Right. So often I have the view that a lot of times they see you were a good mother or a good father until you separated. So I tell all mine when going to a mediation.
I don't mean to laugh, but I mean,
no,
I can totally see that.
Yeah. And so I tell a lot of my clients, it's like, look, when you get into the courtroom, or if you go to a mediation or a judicial case conference, which is a court-mandated mediation we have to go through, be prepared to hear that you're probably the worst parent on the planet.
Right.
If it's a dispute that they haven't come to, because that's going to happen. And I think by managing their expectations that way, they're not as shocked when they hear what
the other one's going to
how
say.
bad they were.
Yeah. All right. Now, we have a couple of different acts here. There's the Child Support Act and the Family Law Act, or litigation. So what's the difference? Okay. Well, and then there's something that changed a few years ago, right?
Yeah. So there's no Child Support Act, but it's actually the Divorce Act.
Okay.
And that's federal.
Okay.
That's historical because in the past, people in Quebec, when Canada was formed in 1867, couldn't get divorced.
It's a Roman Catholic part of the world,
exactly.
right?
Catholics couldn't get divorced. So they said, okay, well, Quebec's not going to pass a law allowing divorce, so we'll make that a federal jurisdiction.
That's got to be one unique part of law that the feds are, because this is all provincial, the rest of it, right?
Exactly. This is an individual to civil, which is under the BNA Act, which it was at the time, is provincial jurisdiction, but they gave it to the federal government for this one area. And what it does, that act dissolves the marriage, but it also deals with child support, spousal support, and child custody and access.
So you go to a different court then? You're not going to provincial court?
The Divorce Act, provincial court has no jurisdiction over the Divorce Act.
Really?
But provincial court deals with the Family Law Act, and our Supreme Court deals with Family Law Act as well, which deals with everything except divorce.
I learned something today. That's interesting.
And the Family Law Act...
that's good. I haven't been divorced, so
exactly.
That's good that I don't know that.
When you know about the act, it's usually not a good thing.
Yeah.
And
there's probably people listening go, Zach, come on. don't you have a couple of notches on your belt? Second wife, third? No, I got one. I'm keeping her.
Yeah, exactly. Especially after doing this show and you see what you got to pay.
Yeah, exactly.
In terms of the Family Law Act, that came into effect just a little over 3 years ago, March 18th of 2013. And that deals with everything except divorce. It uses different terminology. There's no custody under this act. It's just guardianship and parenting time instead of access.
Oh, okay. So is that what's the difference? Access versus parenting time.
It's basically the same term, except the Provincial Act, after years of study and focus groups and such, decided that custody was a loaded term and access was a loaded term. If you're the parent, you didn't want to all of a sudden be just the access parent, because you should have the same responsibilities as the other parent. So they changed it to parenting time. Although now we just fight over how much parenting time.
Yeah. You think that's better, Sarah, than doing it that way?
Yeah, well, there's still a lot of confusion out there, though, because everyone still uses the terms custody and access, so it can be still a bit confusing for people to sort of understand those concepts. But I think I would agree with David's comments that it's less loaded when you're talking about parenting time and parental responsibilities and sharing those. I think it seems to put both parents on even ground, because invariably in most cases one parent has primary residence, whether it's 50-50, somebody has the primary residence. So I think the terms work better and they're more palatable for people than custody and access.
So in the majority of the cases, what is the split typically?
Depends on the age of the child. If the child is under 1 year old at separation,
goes to mom, right? Yeah.
For the most part, and dad will have a number of times a week for shorter periods. 1 to 5, you start increasing more of the time. You start throwing in some overnights during that time. Over 5, it's more of a shared situation. There's no presumption. It all is best what's best for the child. But you start having a bit more shared after 5. By the time a child is 12 or 13, basically they decide where they're going to live. And the
child does?
Yeah.
Really?
Well, they have
what
we call is they have a voice, not a choice. But
because you say, mom's too strict, I want to live with dad. I mean, you must get that too.
Oh yeah, and our courts say,
I did my joke last time about the Leafs. You remember that joke?
Yeah, exactly.
You can say it about the Canucks. Should I say it again?
Sure, why not?
All right. So the kid goes to court, and the judge says, Johnny, who do you want to live with? Do you want to live with your mom? No, my mom beats me. Oh, do you want to live with your dad? No, my dad beats me. Oh, well, who do you want to live with? Toronto Maple Leafs, because they can't beat anybody. There you go. Now you can use that in your office. If
exactly. So
you can say it for the Canucks too, by the way, or the Edmonton Oilers, or every Canadian team.
Pretty much.
It's pretty sad.
Well, the way it works, that by the time they get to be a certain age, they have our court and our act mandates we hear their voice. So after 8 years old, they can have what they call a views of the child report. And even though it's not determinative, the court has the ultimate determination. If a child is definite in their view, and it's not for frivolous reasons, such that dad lets me
stay
smoke
up later,
marijuana, right? Every judge knows that when a child is a teenager and says, I want to go from living with mom to dad or dad to mom, it's because rules are more lax at the other house.
Really? Yeah.
Yeah,
that's common sense, right?
Yeah, judges aren't stupid that way. But as long as it's a valid reason, and the child will usually be allowed to live where they choose at that age.
Even though the judge knows that it's...
Yeah, because as long as it's not against the child's best interest, such as like the new parent that they're going to live with, or the other parent is never home or has wild
travels
parties
all the time.
Exactly. As long as it's not bad for the child, they have a pretty well choice. And because they know that children are going to choose with their feet.
So, circling back to the Divorce Act, how does it typically deal with children's issues? Like, what overarching sort of message can you give there?
Again, it's what's best interest of the child is the determination. So what, you look at what were the roles of the parents in the relationship. Was one parent the primary caregiver, which means, in my generation, it was mom was primary caregiver. Mom was at home all the time. Now it changes. So I think that's why and the reality is there's more of a shared situation, simply because both parents are involved in doing stuff. I know in my own situation, my wife takes care of setting his lunches, and used to be setting play dates, but now he's old enough to choose his own, whereas I took him to most of his hockey practices, and she went to the game. So
well, that's parenting.
Exactly.
You have different roles, right?
Exactly.
All right. Now, what about when one parent wants to move? So here we are in the Lower Mainland. Somebody wants to move to Kelowna, wants to move to Ontario. How do you deal with that?
It's a tough one, isn't it, Sarah?
It's an extremely tough one, because you have to give written notice to the other parent, and then again it really comes down to the best interests of the child, and it will look at sort of all the influences with the child in terms of whether it's in the best interest of that child to relocate, and the court will look at a lot of factors around that. So
the days of mom or dad just getting up and moving and taking the child with is not on.
Yeah, that under our act that's prohibited. You have to at least give notice. If you are a guardian, you have the right to at least apply to stop the move. If you just have if you're not a guardian, just have what they call contact, then you can't stop the move. But you at least have to be notified.
I would suspect, I know it's out of provincial jurisdiction, but say people up in the oil patch, right?
Mm-hmm.
People are, see, there's a family up there and they were making all kinds of money, and the dad had to move for somewhere because there's no work there anymore or whatever. So does the court look at financial influence too? I mean, the dad's got to move because he needs to get a good paying job.
It is a factor for sure, especially now with people meeting over the internet, falling in love with people farther away. There's a lot of moves that way. There's moves for economics. Like one of the major cases was the mom had a chance to get a job down in Australia. Mm-hmm. And it's like, why, even though they don't look necessarily why you're moving, it's if you're moving for a good job or for a new relationship that's going to make you happy, that is your happiness flows through the child. The court looks at everything when it comes to it. It's hard to say what's going to happen in any given case. It's very fact-driven.
And one judge will have a totally different view than another judge. Well,
and one of the issues in the Lower Mainland is how do you define the Lower Mainland? Yeah. That's come up on I think between David and I and Leah on all of our cases. We've had that one case where is it really a relocation? Because no one's really defined the Lower Mainland, and some judges are saying, under 100 kilometers, it's not actually a relocation, so the relocation provisions don't apply. Mm-hmm. Some judges are saying, oh, well, it's this far, it's outside, just outside Lower Mainland.
Yeah,
so
for example, if you lived in Hope, and then you're moving to Squamish, is that still the Lower Mainland?
Exactly.
And that's an issue that's come up on a couple of files. So it can get really tricky in determining if it even fits in as a relocation, or can that parent essentially move? Yeah, it may be inconvenient, but is it a relocation?
I had an even more extreme example. The person wanted to move from South Surrey to Maple Ridge, and the other party filed an application preventing a move. Was it granted? We ended up resolving it, and she settled in living in Langley, Willowbrook. But
that's kind of halfway.
Yeah, exactly. Which is kind of how it worked out.
But that seems a bit extreme. I mean, from White Rock to to Maple Ridge isn't at the end of the world.
The argument was I have to go over the toll bridge twice. It's going to cost me a lot more for travel and everything. So there was all those things that factor in. But the long and short of it is, each case is so fact-specific in what is actually a move. My view, that wasn't a mobility move.
I would suggest most people would think that. But
yeah, exactly.
All right, we have to take a break now. When we're going to get back, we're going to get into the nasty topic of children and money, which is the support part, right? That's where it really gets tricky. All right, we're having a great conversation. David Halkett, from a partner there, Macquarie Hunter in Surrey, and Sarah Morse, associate of Macquarie Hunter. We're talking about children's issues in family law, and we'll continue the conversation next on The Law Show.
There's more of the show still ahead. This is The Law Show on CL 650.